I'm going to toss it over to my friend and colleague Marielle, who's going to talk about the legislation amendments that are about to come into full force and effect under the Working for Workers Act 5. These changes have not yet received royal assent, so Marielle is just going to walk you through what to expect. Marielle, thank you so much. You can take it from here.
Thank you, Charlie. And you mentioned something extremely important, which is that this legislation has not yet received royal assent. So while we will briefly go over some of the proposed changes, it is possible that when they do become law and become enforced, it might be a little bit different than some of the contents in our slides today. First, no one is surprised to hear about the increased minimum wage. Ontario is expecting to raise its minimum wage from October 1st, 2024 to about September 30th next year to the following: $17.20 per hour generally, or $16.20 per hour for students. It can be very expensive to breach the ESA. Let's talk about how expensive it is, because this new act is looking to make it even more expensive. Currently, the fine is up to $50,000 for individuals, and this act attempts to change the maximum fine to $100,000 for individuals who violate the Employment Standards Act. Fines for those who violate the ESA more than 3 times in a 3-year period for certain violations can be fined up to $5,000 per employee affected by the violation. This is a significant jump from the previous maximum of $1,000 per employee affected. The 5th Working for Workers Act also proposes changes to Section 50 of the ESA, which relates to unpaid sick leave. Currently, an employee who has been employed for at least 2 weeks is entitled to an unpaid sick leave of absence if it's due to personal illness, injury, or a medical injury. It doesn't necessarily need to be on the job. The Act does provide an employment minimum of 3 days in a calendar year for this type of leave. Keep in mind, this is just the employment standard minimum. An employee's contract might offer them a little bit more, so check that contract first. An employer can require an employee to provide evidence reasonable in the circumstances to provide the employer who is entitled to this leave. The 5th Working for Workers Act proposes to add in a giant caveat, actually, to this requirement for medical evidence. Previously, an employer just needed to request evidence reasonable in the circumstances. But now, the proposed change actually prohibits an employer from requiring a certificate from a qualified health practitioner as evidence for the purpose of this leave. And qualified health practitioner is defined as a physician, registered nurse, or psychologist, or a member of a prescribed class of health practitioners, which is quite wide. Employers are still entitled to ask for reasonable evidence, but they are no longer allowed to ask, when these amendments come into force, for a medical certificate. One of the biggest changes coming under this Working for Workers Act is the requirements for employers who publicly advertise jobs. For job postings that are publicly available, employers cannot post requirements related to Canadian experience, with a few very limited exceptions. For employers that rely on AI or artificial intelligence during the hiring process, so this includes screening, assessing, or selecting potential applicants, would also need to disclose the use of that AI in a new job posting. Employers will also be required to post the expected compensation or range of compensation for the position in public advertisements, again with very limited restrictions. The Act also does change the definition of employer to include prospective employers. So this does also change the obligations of prospective employers and allows the definitions to be used interchangeably here. Employers have very extensive record-keeping requirements under the Employment Standards Act, and with job postings, it has now been expanded to that too. So employers are required to keep copies of publicly advertised jobs for 3 years after the post is removed from viewing by the general public. There's changes to the Occupational Health and Safety Act as well. So with the increase of virtual workplaces, it's not much of a surprise since the pandemic that Ontario laws are trying to keep up with the new workforce here. It does also expand the employer's obligations to recover remote workspaces. Ontario has updated the definitions, or is working to update the definitions, of workplace and sexual harassment to also include virtual interactions. OSHA is the base legislation in Ontario that provides employers are required to provide employees with safe working environments, which includes environments free from harassment and bullying. And these protections will be expanded under legislation to expressly include remote workspaces, even if the employee works from home. So OSHA does apply to telework in private residences.